The Supreme Court is hearing a case which could have major consequences for the future of abortion rights nationwide. Protesters on both sides of the debate gathered outside of the Supreme Court earlier as justices heard oral arguments. The case centers around a 2018 Mississippi law which bans abortions after 15 weeks of pregnancy and a clinic in the state. Mississippi state officials are using Dobbs versus Jackson Women's Health Organization as a means to overturn Roe versus Wade. The nearly 50-year decision from the Supreme Court established a constitutional right to abortion. This case has reignited the charged and emotional debate over abortion rights, and the stakes are high. Roughly 40% of states are ready to ban all or nearly all abortions if Roe is reversed. But a ruling on this case doesn't necessarily need to overturn Roe. For more on this, I want to bring in Gloria J. Browne-Marshall. She's a constitutional law professor at the John Jay College of Criminal Justice. Welcome, Professor. Great to have you with us. What were the main arguments presented today from the representatives for the state of Mississippi and Jackson's Women's Health Organization?
Mississippi is arguing for states' rights, that they have a interest in the fetus and an interest in women's health, and they believe that 15 weeks is the point in which, after which there should be no abortions, and that they believe that Roe versus Wade should be overturned whole cloth. And then the opponents, of course, the pro-choice side, is saying that the point of viability should be the cutoff for a woman's ability to choose. And even past that, there should be exceptional circumstances that take into account a number of other factors that are taken into account in other countries in Western Europe and other places in the world. They also argue that that Roe versus Wade is a fundamental right for supporting a woman's right to choose, and that fundamental right should not be left to the states or to Congress, that it should be left to the court, and that the history was then debated between the two and among the justices. Where does history stand here? Does history support a woman's right to choose as a fundamental right? And then the pro-life position also be the argument by Justice Thomas was, where in the Constitution is this found, this fundamental right? And the pro-life attorney said in the 14th Amendment is a right of liberty. And they also spoke about economic issues. And so it was a freewheeling conversation among the justices, but little by little you could see where they stood and perhaps where they're going to vote on this issue.
And of course, all eyes are on the three Trump-appointed justices, Gorsuch, Kavanaugh, and Coney Barrett. What could you glean from where their thinking might be headed in terms of the questions they asked?
Well, it was very interesting because some of it was in response to Justice Sotomayor saying that this would be, a horrible thing for the court to be seen as so political. But we know these three justices were put on the court by Donald Trump when he was president in order to overturn Roe versus Wade and to be a conservative voice. And so what we heard from Justice Gorsuch was basically he seemed to just state almost that he was for overturning Roe versus Wade. And Justice Kavanaugh seemed to lean more toward, well, we've overturned precedent before, and then began to recount Gideon versus Wainwright as well as other precedent to say, well, we can overturn those precedent in past cases, so why not overturn this one? But Justice Amy Coney Barrett seemed to be more on the fence. She seemed to know, as a woman with a large family, the care and responsibility of a child, and she seemed to take that into consideration. But she leaned on this issue of safe haven. Why not just have the child put up for adoption, or if it becomes too unwieldy to care for this child, leave the child at a fire station, a hospital, or other places, because states have safe haven laws that would allow a parent to relinquish their rights if they find that child raising has become unbearable.
And, of course, the liberal-leaning justices cited precedent in Roe and Casey. How much does that matter in this case? I mean, precedent is a big deal in the law, certainly when the Supreme Court is deciding cases. Has the Supreme Court ruled against such an established precedent before?
Well, it has, and that was part of stare decisis, the issue of the Supreme Court, even though the Supreme Court justices change, it's the idea that the institution of the court remains the same. And so the decisions made in the past should be the decisions of the present until there is grave reason to change. And there have been cases that have been overruled before. In order to have Gideon versus Wainwright, they had to overrule precedent of Betts versus Brady, which said that states did not have to give an attorney to an indigent defendant if it was a non-capital case. And so there were these cases put forward, but the issue that Justice Breyer brought forward was the fact that when it comes to individual rights, we can't trust the states to maintain individual rights, because if it's majority rule or whoever has political power, then how far would we have come as a society? But what really troubled me was the bantering around of Plessy versus Ferguson as that precedent that was overturned by Brown versus Board of Education. Plessy versus Ferguson gave this country institutionalized discrimination. That was the case in 1896 that provided separate but equal. And it wasn't until many cases leading up to and a lot of lives invested in the overturning of Plessy that we had Brown versus Board of Education in 1954. And so you had Justice Alito saying, well, we know we overturned Plessy. That was precedent because Plessy was a bad law. And it took time for that to be overturned. And I thought it was a point of hypocrisy, actually, for a sane person who's not done anything for the rights of people of color and others when it comes to the Supreme Court is now using the poor decision of Plessy versus Ferguson to say, well, Roe versus Wade was ill-decided. And so therefore, even though it took a long time, just like Brown versus Board of Education, now is the time to overturn it. And so they were using history of 1868. What were the rights of women during that time period to terminate their pregnancies? They went to, as I said, Plessy versus Ferguson, to Brown versus Board of Education. So it was a very free-wielding conversation based on the interests of the different justices.
Professor Gloria Browne-Marshall, thank you so much. We appreciate your insight.